Good afternoon, everyone. Thanks for joining us today. Allison Scobart here with Consolidated Planning Group. We are bringing a webinar to you today, partnering with Hayes and Wilson, Julia Hayes, and we're going to be talking about planning for incapacity. So I always like to go over a few housekeeping items right off the bat. We are in webinar mode today, so in case you're wondering, we can't see you or hear you. We do have a lot of people that join in through podcasts. If you're listening in on a podcast and you would like a copy of the slides, you can email us at contact@cpgcares.net. That is contact@cpgcares.net, or you can reach out to us directly at 281-690-1177. So when it comes to your questions today, we invite everyone to put their questions in the chat box. I'm going to be monitoring the chat box, and as our usual format, we will take questions throughout the presentation. And if you're planning your day and planning your time, this presentation will be 1 hour, so we will have a hard, fast stop at that time frame so you guys can plan accordingly. Consolidated Planning Group, we are a holistic special needs financial planning firm. We have over 30 years of experience. We're nationally certified as Social Security advisors and members of the Special Needs Planning Academy. We do a lot of advocacy. Maybe you're here for the first time, and maybe you've attended many of our webinars in the past. Our advocacy is through our webinars. We do webinars every week, usually from 12 to 1 on topics surrounding planning for a loved one with a disability. We have a YouTube channel. There's over 300, I think over 350 webinars out there on topics. You name it, it's out there. SSI, Medicaid, guardianship, special needs trust. We had a special webinar a couple weeks ago with Temple Grandin. That whether you're thinking about housing, whether you're thinking about transitioning, or you're thinking about legal documents, we've got topics out there, and we've tried to really title them in such a manner that you can find them for the step that you're on in the planning journey. We help people put protection plans in place, lifetime care plans, transition planning. We help set up ABLE accounts. And, you know, we always talk about the difference of what someone like Julia does and what we do, because a lot of times there's confusion. We get calls all the time, Julia, for people saying, hey, could you help us set up guardianship, or could you help us set up a special needs trust, and things like that. And although we refer out to Hayes and Wilson and a number of attorneys across the state for your legal documents, your legal team, they don't do what we do. They're not the money, we're the money, and they're the paper. They're the legal documents that are necessary to have in place, and we're the funding. We protect eligibility for state and federally funded programs. We tell people how much do you need to fund the special needs trust that the law firm set up. So we really work hand in hand. We're separate entities. They don't work for us, we don't work for them. But I always just like to make that clarification, because when it comes to special needs planning, you need a team. And there's different members of the team that need to be at the table. So today, again, we're talking about planning for incapacity. I do want to mention, because a lot of you may know Lisa Wilson. You may have heard of Lisa Wilson from Hayes and Wilson. We have had the pleasure of working with both Julia and Lisa for years. Lisa retired in December. So Julia is handling a lot of the things that Lisa was handling previously. And so I just wanted to mention that in case Julia is new to you. Julia, thank you so much for taking the time to be with us here today. And let's get started.
Thank you so much for having me, Allison. I'm really excited to get started on this. So yeah, you can see the title, Planning for Incapacity, but what does that mean? So I'm going to go over a number of documents that we can use to help strategize, plan for future incapacity. It may even be future unavailability. So maybe you're not incapacitated, but you take a job internationally and you need somebody who's boots on the ground, who can be here and take care of things for you. So there's a number of documents that I'm going to go over, some of which I would recommend for every single person watching this, anyone in this room, any adult. They're just basic incapacity planning documents where we think to the future of what happens if I need someone else to step in for me, either on the financial side or the personal side, making medical and living decisions for me, that kind of thing. And then there are a few documents that are a little more specialized. So it might be that we're looking at mom and dad as they get older, or someone who has a diagnosis where right now they have capacity or they are able to take care of things on their own, but they can look at the future and say, you know what, at some point, I'm going to need a little more help with this. And that could be something like Alzheimer's or dementia, but it could also be a cancer diagnosis where you can look at it and you can see right now, I'm fine, I can do this. But at some point in the future, I cannot. And who can step in? Who can help me with these things? And how do we make that work? And then the third sort of sector of incapacity planning would be those people who, without this plan, might otherwise traditionally be considered incapacitated. So previously, the only options might have been guardianship. And so we, as the parents of special needs children, were looking at that thinking, we have to be the guardian of our children. There's no other option. Well, now there are some other options. And so I'll go through those sort of supports and services, documents that people who do need extra help may be able to put into place. And so that first section is the financial side. And so this is something that certainly Allison, other financial planners are going to be helping with as well. But also you can plan for yourself and you can make some arrangements in place to take care of those things. And so on the next slide, it's the mechanisms for managing income and assets. And so a lot of these you're probably familiar with. Joint accounts. That's a very simple solution. We're going to add someone else to our account. They can manage it. They can pay bills. They can take care of things for us, but it's still our money. We can still also manage it. There's the appointment of an agent under a financial power of attorney. Maybe we're to the point where we actually need a co-trustee to step in and help us out with things, and we might set up a revocable living trust. Supplemental care trusts, I'll go over that in brief detail. If you want to know more on that side, certainly feel free to send me an email, call. That I could talk about all day. So I cannot fit all of that in the hour, but we'll try to give you a brief overview on that. There's things like representative payees for Social Security, Medicaid, other government benefits, and then what I alluded to earlier, guardianship. And so guardianship is not necessarily planning for incapacity. It's what we do when someone is incapacitated and we need to step in for them. But on the guardianship side, there's planning opportunities as well. So in the situations I mentioned before, where right now you are able to take care of things, but you can see that at some point in the future, you may not be able to do, you can at least name who you would want to serve as your guardian. Or more importantly, you can exclude someone from serving as your guardian. So if you've got, the one kid who's a squirrel and you don't want them stepping in for you, we can exclude them. Alrighty, so we can go to the next account. Sorry, next slide. Reading ahead. So joint accounts. This one, like I said, most of us are pretty familiar with that. You've had an account with someone else. It's just that we need to pay attention to how those accounts are styled. So if somebody is just added as a co-signer, that means they can pay your bills, they can deposit checks, they can manage the money in the account, but when you pass, they don't have any right to the money in the account. So essentially that account is frozen until someone has the authority to access it. And so in 2009, the Texas legislative session expanded convenience signers, and you can add convenience signers to a single party account, a multi-party account, an investment account, many different types of accounts in Texas. And so those convenience signers are the ones who would not have the withdrawal rights. They're not joint tenants with right of survivorship. They don't have a pay on death designation. They don't have a transfer on death designation if it's stocks, bonds, securities. And so sometimes you have a well-meaning banker who says, yeah, of course, mom, I'll help you. You want to add your son to this so that he can help you pay bills. And they don't understand that if they're just a convenience signer, they can't pay your funeral bills after you die until the account is probated. So that's just something to pay attention to. And then on the other side, sometimes you have a well-meaning banker who adds a right of survivorship. And then mom dies, but mom has 3 children. And oops, it all goes to son number 1. So those are just things I ask that if you are going to use a convenient signer, you pay close attention to how the account is styled and titled. And I see
I
we've
want
got
to mention here, Julia, how important it is. I know a lot of people don't have safety deposit boxes anymore, but we see some of our aging parents, aging grandparents that do still have safety deposit boxes. And it is important to be intentional on the safety deposit box. Where is it located? Where is the key? Having whoever should be on it, because we've seen those take a court order. And we've also seen families where they have 10 keys and they have no idea where the safety deposit boxes are, which banks they're at, or what have you. And that's fewer and far between. We don't see that as much anymore, but we definitely have seen issues with those over the years.
No, I really appreciate that. That question often comes up, where should I store my documents? And people are like, oh, well, just put it in the safety deposit box. I said, well, does anyone else have access to it? Because if not, then we have to get a court order to drill open the box if something happens to the principal. That can be very time consuming and just a mess.
I think we have a little bit of connection problems with
that.
Julia.
And all right, so
Julia, I think we have some connection problems. She'll be back in just a second. She may have to hop on a different internet connection. While we're waiting for her, on these power of attorneys, and can you hear us? All right, I think she's going to have to jump on a different connection. But power of attorney and the healthcare power of attorney, you know, she's going to go deeper and wider with us on that. But we do recommend, a lot of times, you know, people think of a power of attorney and healthcare power of attorney as it relates to themselves or their aging parents and things like that. But we like to think of this for our neurotypical kids that we might be sending off to college as well. We like to think of the power of attorney and healthcare power of attorney as a good document to have in place in the example of sending an adult kid off to college. So, okay, Julia is back. Sorry about that. So anyway, we were just waiting for you. No worries. We were just talking about, we didn't go deep and wide on the power of attorney, but I was just going over our suggestion that we have a power of attorney and healthcare power of attorney for our neurotypical kids that we are sending off to college. It's a good idea. It's not just for the parents or just for grandparents and things like that. So talk to us more about this.
Yeah, absolutely. And so can you guys see me? For some reason, I cannot see myself, but I'm going to assume you can see me.
We can.
Okay, wonderful. Then I'm just going to move on with my life and assume that you can see me. Hopefully I'm in the screen. Sorry about that. For some reason I had to switch to my phone, but I had it readily available. So yeah, power of attorney. So first of all, power of attorney does not take any power away from the principal. So it's not like guardianship. So you and I can make a power of attorney. We appoint an agent who can act on our behalf, but we can still manage our own income and assets. And so that's not something that you can get over someone else. So we sometimes get the call that says, oh, mom's in the hospital. Can you help me get power of attorney over her? I cannot. Mom can appoint someone as her agent, and we're happy to work with her, but we can't just get it over someone else. It's not something that you can go in and add yourself as an agent. And so what the power of attorney does is it authorizes someone else to act for you in any number of financial capacities. So dealing with income and assets, that might be calling insurance companies, talking to banks and moving money around. It could be calling your utility companies, calling Medicaid, calling Medicare, dealing with Social Security, tax, real property. There's now even a provision for digital assets. So it gives you a pretty wide range of things that you can help someone out with. And when I say incapacity, it doesn't have to be incapacity. So you could have your agent under the power of attorney go into effect now, maybe you're traveling and you know that you've got a closing on a house coming up and you're not sure exactly when your house is going to get sold, and you want to make sure that someone else can sign for you on that transaction while you're out of town. That's a perfect use of the power of attorney. And in the cases of our children who might be turning 18, going off to college, we want to foster their independence. And so having them appoint parents as an agent under a power of attorney is great. It means that they can manage their own income and assets, but maybe the parents can step in and help them navigate school bills, tuition payments, things like that. But of course, in fostering their independence, if they choose to name someone else as their agent, that's also acceptable. So the parents, like I said, can't just step in and become the agents. Once they're 18, they're grown, but it may be nice for the children to still have access, and the parents can step in and help out with all of those various things. And so the power of attorney covers, oh, go ahead.
I was just going to mention on the power of attorney for colleges, the colleges, they are still going to require a FERPA, and sometimes that makes people upset because you have this power of attorney and you can call, but they have their FERPA document that is required to be signed by the student to release school records. So that may be in addition to that. But I guess powers of attorney die with the person. So if a person dies, those rights are terminated. Any rights that you had while the person was living, that is done, correct?
That's exactly right. Yes. So this document and several of these documents are only good during your lifetime. Once you pass, they no longer have any more effect. We're going to switch to a different document at that point. And so on the power of attorney, we typically give pretty broad powers. I mentioned a number of categories in which the agent might be able to act, but there's also an ability to add hot powers. And so that means that the attorney who drafts the power of attorney document can put in additional powers that the agent might be able to take care of for them. And so we talk a lot about managing gifts. If you want to do any kind of annual gifting to kids, grandkids, church, charity, whomever you might make those annual gifts to, if you already have a history of making those annual gifts, you can authorize your agent under a power of attorney to continue to make those gifts. Likewise, if you needed to move some money around so that one person might qualify for Medicaid, that gifting power sometimes can be very helpful. You can put in there that the agent under the power of attorney has the power to create or amend trust for your benefit, to make changes to any type of retirement products. So that might be IRA, 401k, life insurance, annuities, pensions, any of those retirement products. You can put in your power of attorney document that your agent has the authority to make changes to that. And in our planning, since so much of it does focus on the special needs planning, we find that one particularly helpful because we've set it up. All three kids are the beneficiaries, but actually child A is on government benefits, and we want what child A receives to go to a supplemental care trust. If the agent can go in and update those beneficiary designations to pay to the supplemental care trust, child B and child C, that can be extremely helpful. And then there are other things that the hot powers can include, like the agent has the power to delegate their authority to someone else. I typically recommend against that. I don't think that that's a particularly good idea. I'd rather my principal picked an alternate agent, but you can write that in there. So if you only have one kid, trust them implicitly, and you say, okay, well, if you can't do it, I want you to appoint your successor. Great, you can write that in there. And then you can also account for compensation. So for most of us, our agent under the power of attorney isn't actually going to be doing a whole lot of work. Maybe stepping in for one or two transactions, maybe watching our bank accounts to make sure that we're not being defrauded or whatnot. But for the most part, we're managing our own stuff. But in some situations, our agent under the power of attorney is basically serving as our trustee. They are paying all of our bills. They are stepping in when we cannot, and they are taking care of everything for me. And so it might be a good idea that they be compensated for their time. And so you can address that in the document of whether they receive compensation, for what actions, or whether you don't want them to ever receive compensation. There are certain limitations on a power of attorney. So one of the things that Allison alluded to was what happens if you die. it's over. It's done. It doesn't work anymore. So, that's a major limitation of a power of attorney. But also, if you are representing someone before Social Security or the Veterans Administration, they can always insist on working with the principal. So when we talk about our kids going to college, or our 18-year-old who maybe needs a little extra help, and they try to deal with some of these government entities, the entity might insist on working with them unless there's a representative payee or a diagnosis that would qualify them for Social Security, disability, those sorts of things. So just, be aware that agent under power of attorney is super helpful, not the be all end all. It doesn't force every third party to work with you. So
I'd like to mention on that, with the Social Security Administration, they definitely recognize guardianship but not power of attorney, to your point. But just because you don't have guardianship of said individual with a disability does not mean that it's not possible for you to be a representative payee. So if, there's plenty of people that are the rep payee for their loved one that they don't have guardianship, and that is okay. Before we move on, one thing that I want you to talk about, Julia, is what about when we have someone that doesn't have capacity sign a power of attorney? What are the possibilities of calamity? So I guess what I'm getting at is sometimes people do need to be under a guardianship. They may not have the capacity to understand what they're signing, but a parent said, hey, sign this, and the kid
Sure.
signs it. What are some issues that could come up as a result of that?
Right. So, of course, one of the main issues is fraud. So we don't want people to sign powers of attorney not knowing the effects and the consequences and all of these things that your agents are able to do, because it can be used as a tool for theft. In the case of the parents that are having their child sign it, hopefully that's not their goal, but it also, you run into some major problems there of third parties not understanding that the principal still has power and what the effect of the designation of the agent are. So hopefully when somebody signs a power of attorney, they're doing it, and I, not just saying this because I am an attorney, but doing it in an attorney's office, because part of our ethics training is to go over the documents with the person who's signing, make sure they understand them, make, sort of a informal capacity determination. Do I think that this person knows what they're signing? Do they know what this means? Do they have contractual capacity? And I have definitely told parents, I'm sorry, I don't think that this person can sign this document, that you need to get guardianship. On the other hand, there is a movement in Texas away from guardianship. So guardianship is a proceeding to take someone's rights away. And so if we're going to do that, we want to make sure that this person really would benefit from that they need this in order to be protected. And so sometimes the courts will understand if we're going to try having an agent under a power of attorney or a medical power of attorney or a supported decision-making agreement before we move forward with guardianship. And then if third parties aren't accepting them or the agent can't get it done using that document, then we move forward with guardianship. But yes, absolutely. There are times that it is extremely clear to me that this is a person who can't understand the document and does not understand the consequences of signing this document, and I won't notarize it for them. I'm not going to go forward with that if there's any question.
You personally have a line in the sand or an IQ score. I've heard some over the years say, 70 or below. And intellectual disability is, that is 70 or below. Do you have a line in the sand, or are there many other factors that you take into consideration?
Yeah, I don't have a hard line in the sand. In fact, most of the people who come into my office, I wouldn't have any idea what their IQ score is. I wouldn't have a doctor's evaluation. And so it's going to be, can they have a conversation about what they want their agent to help them with? And this goes not just for, the younger people, it goes for the aging adults as well. So does mom have good days and bad days? Does she sundown? In the mornings, is she really with it? And then the afternoons, not so much? Then I'm not going to have her sign it in the afternoon. then I would talk to her in the morning and make sure that she understands that this can be used as a tool for theft, that this can be used to take advantage of her. Does she trust the agent? Sometimes I will kick the agent out of the room, or actually that's pretty much my policy, is that if the named agent brings someone in, they need to leave the room. And I need to talk to the principal and make sure that they understand what they're signing. And then I can feel comfortable about them signing. So yeah, it's a multi-factor test. It's, do you want this person helping you? Do you understand how they can help you if they are named as your agent? That sort of thing. And I think I saw a chat question pop up, but I'm on my phone, so I can't read it.
I gotcha. So
Thank
how
you.
do you reverse guardianship when a guardian dies? I have a consumer whose guardian died and now is in the battle with cousins and the state.
So I think that that's a two-part question. So if the guardian dies, generally we're just looking at getting a successor guardian. And so the next family member or the county guardianship program, whoever it is going to step in and qualify to be the guardian. To reverse guardianship, it's essentially the same process, but in reverse. So we need medical evidence that shows that this person now has recovered enough or improved enough that they are no longer fully or partially incapacitated. So it may be that we make an application to the court with the doctor's letter to restore some of the rights. So we think that this person can drive. We think that this person could manage a small bank account, but they couldn't make complex business decisions, that sort of thing. And so same process. We get the doctor's letter, we make an application to restore their rights. Because of this movement away from guardianship, the courts are generally pretty open to rights restorations. That's actually a very happy day in guardianship court when we can restore someone's rights. But there still has to be the medical evidence showing that this person no longer has a deficit in this certain area or can perform these actions either with supports and services or on their own.
Thank you for that. And then I actually do have one other question as it relates to that and it kind of
Sure.
the movement. Sometimes, we work with some families that it is very, very clear that the individual needs a guardianship, but sometimes because of this movement in Texas, which is basically least restrictive, most appropriate, which is not wrong, least restrictive, most appropriate. But sometimes because of some of this movement, it is almost like the message that is being sent out is that guardianship is bad and that you should never, ever have guardianship. And then I have concerns for some of their loved ones that clearly couldn't transact business on their own. They don't drive. They couldn't get themselves to appointments. They couldn't live independently. They couldn't handle any of those things. What about the other side of that?
Yeah, so I actually am far more concerned about the cases that are borderline. So if it is extremely obvious that somebody cannot take care of themselves, if you show up in the emergency room with them, then the medical professionals are going to be super happy to talk to someone who can consent, who can understand, that is making choices and helping out this person who obviously needs it. The concern comes in on the cases where someone may be able to take care of themselves to a small degree, but they are at risk for third parties coming in. They're at risk for somebody, on the internet who convinces them that they're in love with them and come marry me, and they're looking to financially exploit this person. We have a lot of cases where, the children are 18 and they're excited to get attention from someone else, but they're also at risk of a malicious third party coming in and taking advantage of them in a financial way, in other ways, in emotional ways, and be exploitive. And so on those cases where we're moving away from guardianship, I worry a lot about them because there isn't somebody who can void contracts that they've signed. There isn't somebody who can make decisions about where this person is going to live or consent to medical treatment. And that person is not necessarily the best person to make those choices for themselves. So, you're absolutely right that less restrictive alternatives are what is the right thing to do. We should be considering every way to make everybody more independent and be able to advocate for themselves. But there are some of our kids who are certainly at risk if they don't have a guardian.
Thank
Okay,
you.
so I have spent a fair amount on the financial side. So I'm actually going to flip ahead, and then if we have time, we'll come back to some of these financial powers and go to the medical side. So Allison, I believe it's slide 14 for me, mechanisms for making medical decisions. There we go. So under the state of Texas, every person has the right to make, every adult, excuse me, has the right to make medical decisions for themselves. So as long as we're capable, each of us gets to make our own medical decisions. And so that might be refusing treatment. We might say, you know what, I'm at the end, I don't want life-sustaining treatment. It can be consenting to treatment. It can be anything that you and I have been asked to do. We are supposed to be able to do that. However, if we're in a hospital, if we're incapacitated, if we can't consent because we do not understand the ramifications of consent, so it's not just consenting to treatment, but it's understanding that it comes with risks. It's understanding the risks of not performing that treatment, that sort of thing, then there is a statutory surrogate for who can step in and make those decisions for us. And that's not always who we want it to be. So if you're not married, the statutory surrogate is a majority of your adult children. Well, my adult children might be all over the United States, and it's not that we can get in touch with all three of them in this emergency situation. So you're better off doing some documents that appoint who can act on your behalf. The medical power of attorney only goes into effect when you're incapacitated. So unlike the financial power of attorney, where you might say, oh, I'm going on a trip, or I've got a broken femur, so I'm not available, but I'm not incapacitated. This medical power of attorney only goes into effect if you're incapacitated. But when you are incapacitated, your agent under the medical power of attorney does have the final say. So if you could flip forward 2 slides. Perfect. That means that your agent can consent and say, yes, do the surgery. It also means that your agent can say, you know what, it's time to let her go. I'm going to make the decision to withhold life-sustaining treatment. There's only a couple of things that an agent under a medical power of attorney cannot consent to. So voluntary commitment would be one of them. If there's a psychotic break, they cannot consent to voluntary commitment. You may be involuntarily committed, but they can't consent to voluntary commitment. They also cannot consent to abortion or electroconvulsive therapy. But other than those 3 exceptions, your agent under the medical power of attorney can essentially step in for you and take care of those things. And we hope that the person that you name is your family discussion leader. So we want them to have the emotional capability to make the decision that you would make and follow your wishes, but also hopefully they're involving everybody in your family who might need to be involved on that decision. So with the medical power of attorney, we always recommend that somebody do a HIPAA authorization. Honestly, you've probably filled one of these out every single time you've been to the doctor in the last 15 years. So HIPAA is a government privacy act of who has access to your medical information. And on that, it's not in order of priority. So whereas your agent under medical power of attorney, you might say, I want, Bob first and then Stan second. This is all of these people that I name under my HIPAA authorization have the authority to call the hospital, find out what's going on. We found these to be super useful during some of the COVID shutdowns. You never know, they might only be allowing one visitor, they might be allowing no visitors. Having a number of people who can call and find out what's going on or be in on your doctor's rounds, all of that, incredibly helpful. And then the third document in the suite of medical documents is the directive. So that'll be on the next slide. Directive to physicians is also known as a living will. So this is not a DNR, has nothing to do with emergency resuscitation. So I always tell my clients, if you collapse in my office, I'm going to call 911 and they are going to try to resuscitate you. So a directive is where you're making a decision about long-term life-sustaining treatment. So this would be a situation where without this medical intervention, you'd be likely to die. So think of things like artificial hydration, nutrition, ventilation, cardiac support. They do include dialysis, although many people are able to go do dialysis without having an agent intervene, without anyone else making that decision for them. But if they were unconscious, if they didn't have the capacity to consent, this directive would give an indication of what their treatment preferences are. It is a statutory form, so it doesn't anticipate everything that you can think of. I have clients who come in and give me all kinds of interesting scenarios. That's not covered. This is just an indication of what your treatment preferences would be to try to give guidance to your agent under a medical power of attorney. So it does go through two scenarios. One is if you've been diagnosed with a terminal illness. So terminal is defined as no matter what they do, you're expected to pass away within 6 months. So that would be something like aggressive pancreatic cancer. So it's not responding to immunotherapy. It's now at the point where you require life-sustaining treatment, and you are also not able to pick and choose and say, yes, I want A, B, and C. When it gets down to X, Y, and Z, I'm done. You don't have the capacity to advocate for yourself anymore. And so your options are withhold life-sustaining treatment, which means just give you palliative comfort care, allow you to die as gently as possible, or do not withhold, which means do whatever they can to prolong your life. And so on this document, you'll indicate what your treatment preferences are, and hopefully your agent under medical power of attorney is then going to follow them. The second scenario on the directive would be if you have an irreversible condition. So that's not a coma. A coma is typically considered reversible. This would be something like a vegetative state. And so again, same choices. Do you want to withhold life-sustaining treatment? Or would you say, no, keep me alive for another 30, 40 years on life-sustaining treatment? The directive also has a place for people to write in or attach additional requests. So if they are diagnosed with something and they have a better idea about progression of illness and treatment options, that's where they could detail, yes, I want to try the following things. And when we get down to this point, I'm done. It's time to let me go. Or, sometimes we see people who have a religious objection to blood transfusions. They can put on there absolutely no blood transfusions. And so it allows a little more autonomy when we're incapacitated. So we've made these decisions ahead of time. It still has the human element of your agent under the medical power of attorney who can go back to your doctor and say, okay, she said withhold life-sustaining treatment if it's irreversible, but I want to see another MRI. I want to see if there's a glimmer. Great, do that, and then you can make the decision, and you can make an informed decision. And hopefully this helps take the emotional burden off of whomever you name as your agent. They're not having to choose. They are just following your wishes.
Julie, I wanted to go back on naming of the agent, because I think that there is definitely careful consideration that comes into this. Being someone's medical power of attorney is not for the faint of heart. In the example of a terrible accident or a stroke, or there's all kinds of things that come in, emotions that come into play. It's your kids, they love you, they don't want to make these decisions, or maybe one of your kids has severe anxiety or other things like that. So really, really think about it. It doesn't have to be your oldest child. It doesn't have to be your child. Really think about who really gets you and who really understands you, and who do you know beyond the shadow of a doubt in the worst scenario can stand this, because it is a tough job. And I think sometimes when people are naming people, that doesn't always come to mind at first.
Oh, yes.
So,
and I encourage people to think about their particular skill sets. So it may be that you have one child who's great at managing the finances and keeps beautiful spreadsheets and couldn't make an emotional decision to save your life. And then you've got the other child who's very cool and level-headed, not great with money, but would be there at the hospital with you, could understand what the doctors are saying, would advocate for you, would follow your wishes, whatever they may be.
We have a quick question. It says, if a guardian has control over a person's financial and healthcare needs, why be a guardian, not a power of attorney and or healthcare surrogate?
Yeah, that's a wonderful question. So to address the first part of that question, you said, what if you're the guardian over both the person's finances and the medical decisions where they live? So thank you for flipping to that slide, because that's exactly where I was going with this, is that there's two types of guardianship. Guardian of the estate manages the money, investments, income, assets, all of those things. Guardian of the person makes medical decisions, makes living decisions. So does this person live in a group home, in assisted living? What happens with them? And they're responsible for the physical well-being of the person under guardianship. And so if you're guardian of both, and the question is, why not just be their agent under a financial power of attorney and medical power of attorney? Why go through the court process of becoming someone's guardian? So a couple of reasons. One, the person under guardianship might not have the capacity to sign those documents. So as I said before, you can't get a power of attorney over someone. They have to be able to give it to you. So they have to be able to understand the documents. So for many people, their incapacity is such that they cannot sign and understand those documents. And so that's a non-starter. If they don't have the ability to do that, then our only choice to make sure that somebody is taking care of all of those things for them is guardianship. And I think that would probably be the main answer there. The other things to consider is that a guardian is a court order. So you have court authority, and you have a court that you can go back to if third parties are not playing ball. So say you go to the bank with the designation of the agent under the power of attorney, and they start balking. They say, oh, well, it needs to be on our form, and it needs to be filled out within 2 years. And we have to see, A, B, and C. There are now some restrictions under the law where they can't just refuse to accept the designation of an agent under a power of attorney. They have to give one of 10 enumerated reasons why they're not accepting that, but they do have reasons why a third party can refuse to accept that agent under a power of attorney. And some third parties don't seem to follow the rules at all. Like I said, Social Security plays by their own rules. And so they can always insist on working with the principal, in this case, the person who would be under guardianship. And so a guardianship, they have to work with the guardian. If you have a problem, like I said, you can go back to the court, get a show cause order of show me cause why you are not doing this, why you're not following the guardian's instructions, why you're not taking care of this person in the way that the guardian has instructed you to do. So it's just a little bit more, well, it's a lot more legally enforceable. And there may be an issue of the person under guardianship couldn't have signed those documents in the first place. But that's a great question, because if we can avoid guardianship and it can be done under these other documents, great, let's do that. Save time, save money, and give that person more independence, keep their rights, all good things.
For sure. I just wanted to mention with the Social Security Administration, because we definitely have had families, myself included, I have kids with disabilities, where we ran into issues with them because the guardianship wasn't in place. And like I said, they really do not recognize the power of attorney. Sometimes you will speak to somebody and they will allow the parent to be on and talk. I know that when we did our SSI application, when one of my kids was 18, she didn't know any of the answers to any of the things. And it was like, and our agent was not nice, and they didn't want to hear from me. And I was like literally writing down and mouthing to her like what she needed to say, because she literally had no idea. Right. But that can happen. Now, the other thing too that might be helpful in that situation, because I'm not saying, well, you definitely need guardianship to apply for SSI, because that's not at all what I'm saying. But what I am saying is documentation in the medical records indicating that your kid may have a lack of understanding, or they have a communication disorder, or some other reason on why you need to be their representative payee. And again, then you will avoid that. You'll avoid that problem. So it is important. It is frustrating that, all the whole rest of the world takes these documents, but some of our government entities do not. But it is a fact on how that works.
And to that point, if you are having problems with various government entities, this is just a practice tip, I suppose. I have found that if you make an appointment and you show up at Social Security office with the person in question, and it is very obvious that they can't advocate for themselves, that sometimes things get done that they told you over the phone could not be done. So it's a pain in the butt. You're sitting there waiting to talk to someone, but being in person and being in their face is helpful. Alrighty, so I do have a slide on representative payee, but I think you covered it, Allison, so we don't need to go back to that. One thing I don't have a slide on, and if you guys want to know more, I'm happy to create a slide and send it over to Allison so that she can include it when she sends out the PowerPoint if you ask for it, is a document that was created under the Texas Estates Code very recently. So that would be a supported decision-making agreement. So that's like a financial and medical power of attorney light, a diet agent under a financial and medical power of attorney. So the supported decision-making agreement is a document that was designed for persons with disabilities who, and give me 1 second, my mom is calling in, so I'm going to hit end. Sorry about that. That's the problem of working on my phone, but obviously I have a good relationship with my mom. Anyway, so the supported decision-making agreement is a document that anticipates that the person signing it maybe doesn't have the capacity to sign a financial or medical power of attorney. So the capacity threshold that we talked about earlier, is there a certain hard line of intelligence or certain factors that we consider? It's a much lower threshold for signing this document. And what that document says is that I want to appoint someone who can help me make decisions. They are my supported decision maker. So it's not creating a fiduciary role in the same way that the appointment of an agent would, but we've found it super useful for our 18-year-olds, 19-year-olds who might not be able to advocate for themselves. They might not be able to communicate as effectively. And they get to go through and check what mom and dad can help them out with. And so can they help them with psychological treatment, physical treatment, with setting up a bank account, getting a job, all of these various things. And then with that, we usually attach the FERPA and the HIPAA. So those are the two documents we talked about earlier of who has permission to access the records. And so if you say, mom and dad can help me with school, then they sign a FERPA at the same time that allows them, the parents, to access the school records, access the financial records, those sorts of things. They sign a HIPAA authorization at the same time that says, yeah, mom and dad can talk to my doctors. They can see my medical records. And it doesn't have the same teeth that an agent under a power of attorney has. Like I said, it's the diet version. But I think that it's a good start in thinking about what we can put in place where we let these third parties know that someone else is going to be advocating for this person, that there's going to be someone else who's going to be communicating and helping this person make their decisions. Because even if they can make their own decisions, they can't always communicate them, or they might not want to with a stranger. I mean, that's kind of hard for all of us to do, but especially for, what I would consider a kid just becoming an adult who may need a little extra help along the way. So I don't have a slide on that, like I said, but happy to pull that together and give you a little more information on the supported decision-making agreement if there's interest.
I just wanted to mention, because we do have people that attend from all across the U.S., not just in Texas, the supported decision-making agreement is approved in some states and it's not approved in other states. So if you're attending from out of state, you'll want to check with your state to see if the supported decision-making agreement is a thing in your state.
Yeah, no, that's a great point. These are all Texas-specific examples that I'm giving. And so if there's something that comes up, I'm happy to find you the right person in the various states that can answer that question for you. But assume that something like the supported decision-making agreement, because it's so new, is only available in Texas at this point. I think there are a few others, as Allison said, but it's not uniform probate code. It's not uniform across the board.
For sure.
So I've got.
Can you tell us a little bit about when somebody should engage your services? Like if somebody's thinking about guardianship, clearly nobody needs guardianship prior to the kid turning 18, but how far in advance should somebody reach out to start the process if they want to make sure that it's in place pretty close to the time that the person turns 18?
Yeah, absolutely. So You can get guardianship for someone who is under 18. If the natural parents have died, you might become the guardian of the person, or if they've inherited. So minors can't own property. So we might get guardian of the estate for a minor. But typically we're looking at somebody once they turned 18, their parents are no longer their guardians. They're grown-ups, they're adults, except that you and I know that maybe they're not. They can't take care of themselves on their own. And so typically we start the process if the parent or other family member knows that this person is going to need a guardianship when they turn 18, we start the process 6 months out. It doesn't have to be that far in advance, but we cannot file an application for guardianship before someone is 17 and a half. So, there's not really a lot of incentive to get started before then because we can't file the application with the court before then. And it all starts with medical evidence. So you get a doctor's evaluation showing that this person is either totally or partially incapacitated. And then from there, we would file an application for guardianship. And so the doctor's evaluation has to be done within 120 days of our filing the application. So sometimes we've got clients, kid turned 17, oh, this is the year, I'll go get the doctor's evaluation, then you guys can get started on the application, file it when they're 6 months out. We can't. It needs to be dated within 120 days of our application. So, at most you can start this process 9 months out, but that would require us to file, kind of the last possible date from the 120 days. I don't want to do that. Just get your doctor's evaluation about 6 months out and we'll get started from there.
And it does have to be an MD or a DO when it comes to the evaluation. Licensed clinical social workers can't sign off on that. A psychiatrist, a psychologist could.
So there have been some changes to that within the last couple of months. So in the last legislative session, they changed that where a nurse practitioner, and I think there's a number of other specialties, can do the actual examination of the proposed ward, and then a doctor has to be overseeing it and sign off on it. So it doesn't require that the actual evaluation be done by a physician. But yes, I mean, we typically say if they've got a regular pediatrician, someone who's familiar with them, great. But it can also be psychiatrist, neurologist, psychologist, DO. There's a number of different paths to get there.
Perfect. So always from an inquiring minds want to know, can you give us an idea of getting documents set up? Kind of give us a range of a non-contested guardianship, give us a range on what that usually runs. And then if somebody needed to get their basic documents, wills, power of attorney, HIPAA release, healthcare power of attorney, that kind of stuff. A lot of times people ask that, so they're kind of planning financially, what are we looking at and what is it, if we need to add a special needs trust, those types of things. Give us a range.
For the cost or the time?
Yes. Cost.
Okay. Yeah. So I hate this because I'm a lawyer, and so I'll say it depends. But for a package for, say, an 18-year-old going off to college where we're just doing financial and medical power of attorney, that would be $300. If we're throwing in a supported decision-making agreement and the FERPA and HIPAA, we charge about $600. For the entire will package, so wills, powers of attorney, medical power of attorney, HIPAA, directive, guardianship documents, the whole suite of documents for mom and dad, so people who have capacity, we're typically looking at, and I don't remember what it is for a single individual, but for a couple, $2,300. And then for guardianship, that can range anywhere from $3,000 to $5,000, just depending on what part of the state you're in, what court. We do everything we can on a fixed fee basis. People like to know what it costs up front. And frankly, I don't want to inhibit anyone from asking questions. So when you call, the meter's not running. You know what it costs. We're going to take care of it from start to finish for, $4,500, something like that. In the guardianship context, there are a couple of things that could vary as far as costs go. So part of the guardianship process is the appointment of an attorney ad litem. So this is an attorney who is representing the interests of the proposed ward. So the proposed person under guardianship gets their own attorney to advocate for their interests. So in Harris County, where we are, they typically cap an uncontested, normal, straightforward guardianship at $700. But in some of the surrounding counties, I have seen that go as low as $300 and as high as $1,200. So that's one of those factors that we can't control for, but you can just kind of plan that there will be a fee for the attorney ad litem that's typically paid for by the person who's trying to get guardianship. In certain circumstances, if the person under guardianship is indigent, we can ask that the court or the county pay for the attorney ad litem's fees. So that's something to consider as well. And then the court costs, I don't know, $300 to $400 in filing fees and various costs. So letters of guardianship, things like that.
Awesome. I just like to mention, I don't know if we have anybody attending from Galveston. If you live in Galveston County, they have like a grant, and guardianship is free in Galveston County, but you actually have to be a resident of Galveston County. There are a few, very, very few, and they're so far away from here, I don't even know where they are, other counties that do that. But Galveston is one that I know is in the greater Houston area that does that. And there are also guardian options for, for people that are indigent or have, less money, that there may be some programs, discounted programs through, there's various legal aid programs. Is there any others that you would like to name as well?
The Houston Volunteer Lawyers, they take a certain number of guardianships. And in fact, one of the ways that they incentivize we lawyers to take on those cases is they'll give us CLE. And so we'll do our continuing education in return for taking on one guardianship case. And so those are going to be other attorneys like myself who regularly practice in this area. And in fact, in Texas, in order to file in a guardianship case, you must be certified as a guardian ad litem. And so anyone who's filing in a guardianship case should be very familiar with the ins and outs of the guardianship laws. And so I highly recommend Houston Volunteer Lawyers. I know there's Lone Star Legal Aid. Can't tell you about other states, but I think they probably all have similar programs that if you are taking care of a person with a disability, they are very happy to have you come into court and they want to make it easier for you. So do look for some of these low-cost options if you need it.
For sure. Well, Julia, thank you for taking the time to be with us here today and talk to us about these important topics. Again, you guys are going to get a copy of today's slides with her contact information, how to reach her, and we will also send you a link to this recording as well. We appreciate you guys taking the time to be here with us this afternoon. Definitely reach out to Hayes and Wilson. You'll be glad that you did. Thanks, Julie, again for being here with us, and I hope everybody has a great afternoon. Take care.